today's topic is going to be export controls compliance, and I'll start with a sort of a broad overview of the subject matter, and then dial down a bit into the biospace. So first of all, why are export controls regulations important? They're critical because from a U.S. perspective, these are laws and regulations that essentially enforce foreign policy and national security. And so from a publicity or PR perspective, it's generally seen as a bad thing for your company to have violated US export controls laws. On top of just the PR issue, there's of course civil and criminal penalties, which we'll get to in a second. Steep legal costs associated with mitigating penalties in this area. There's a disruption of business. And then the potentially most critically, if you're in some cases, if you're determined to have violated U.S. export controls laws, you can be essentially you can lose your export privilege. You can be debarred from exporting. So there are two main agencies that regulate U.S. export controls. The first is the Department of Commerce's Bureau of Industry and Security, or BIS. This is the agency that regulates the export of dual-use goods. Dual-use goods are goods that may have a military application, but that also have a civil application. And then, of course, this same BIS agency also regulates single-use goods that don't have a military application. And that's probably the agency and the sets of rules that are most applicable to all of you. There is another agency within the State Department called the Directorate of Defense Trade Controls, the DDTC. This agency is strictly concerned with enforcing export controls on defense articles, defense services, and certain brokering activities. So again, strictly speaking in the military domain. Like I said, I suspect that for most of you, the core concern here are dual-use goods and therefore BIS. But if for instance, you're producing goods or you have information that you've developed that has a military end use, that has been designed for a military end use, then it's possible that your export controls, that your products and your information could be subject to State Department jurisdiction. So the penalties in this space are severe, again, because the US sees this area as an extension of foreign policy and national security. Penalties here are driven by fairly steep laws. They can go up to the greater of $368,000 per transaction, or twice the value of the transaction, whichever is higher. And of course, you can have multiple violations multiple charges per violation. So you can see how this could escalate fairly quickly. The other thing is BIS has a 5-year statute of limitations. And so if they determine that you violated the law, they can look back 5 years from the date of the initial violation they've discovered, and they can hit you for $368,000 for each violation within that 5-year period. In many cases, these penalties can be mitigated down if you file a disclosure, if you can point to mitigating factors, if you implement remedial measures, etc. Right? There are ways to mitigate these penalties, but the starting point is very steep, and usually the end point can also be fairly steep. On top of these administrative penalties, if you're deemed to have been, willful or grossly reckless in committing these violations, you can be charged with criminal penalties that can go up to $1 million per violation and/or up to 20 years in prison. So a bit more on BIS. Again, this is the agency that's authorized to regulate exports by the EAA. The set of regulations that they implement are called the Export Administration Regulations, or EAR. You'll see that acronym a lot in the export control world. And again, they're tasked with enforcing prohibitions on trade with certain countries, entities, and individuals. All of the goods that are subject to EAR jurisdiction, and therefore BIS's jurisdiction, are listed or captured by the Commerce Control List, and we'll talk more about that, or CCL. And then I've highlighted here the regulations and the website for this agency. And these slides will be available to you guys. There's a lot of information here. Not all of it I'll have time to cover, and so Feel free to peruse the deck, and if you have questions, reach out. So what is an export shipment? This may seem like a simple question, but it actually isn't. Obviously, it covers exports of hardware commodities of US origin or foreign origin goods that are sitting within the US. It also covers foreign goods that incorporate more than a de minimis amount of US origin controlled content. And in some cases, it controls foreign goods that incorporate barely any US origin content if they are the direct product of certain sensitive US technology. Beyond physical items, it also controls what the EAR refers to as technology. And I'll talk about technology. In the EAR space or in the BIS space, the word technology refers to information that is necessary for the development, production, or use of controlled hardware. So beyond technology, the EAR also regulates software. Not all software, but software that is, again, designed to control controlled hardware, or software that incorporates more than certain encryption functionality that exceeds certain thresholds. On top of direct exports, meaning the idea of things leaving the US to a foreign country, the EAR also, again, controls re-exports of items that are subject to the EAR, meaning goods that are, say, going from China to Russia. If that good remains subject to the EAR, and therefore BIS will exert jurisdiction over that product. And then the third type of export that's critical here is the idea of a deemed export. And this is a critical concept. A deemed export occurs where in the US, controlled information is shared between a US person and a non-US person. And I'm sure this happens a lot in your context, right? So if you are developing information that is controlled, if you have non-US persons that come to your facility, say engineers from a home Chinese office, that controlled information cannot be shared with those non-US persons. That is perceived by this agency as an export to the citizenship of that foreign person.
Matthew, do you mind going back? Can I ask you a question? Because I'm imagining that people might have questions because there was a lot of slides. So I think it's better that we ask it while you go along.
Yeah, of course.
Do you want to explain to the audience that what is this de minimis amount of US components mean? And can you give an example on that?
Yeah, so the de minimis rules essentially say for a good that is sitting overseas or produced overseas, if it incorporates more than a threshold amount, and it's usually a percentage of value of controlled US origin content, then the US considers that the whole finished product, despite only containing a small portion of US content, remains subject to US export controls. And the percentage threshold varies depending on what the destination is. So for the most part, for let's say China, most goods that are going to China, so long as they're not going to a listed entity in China, are subject to a 25% de minimis threshold, meaning if a good produced in, say, France incorporates more than 25% origin by value, US controlled content, then the US, and it's going to China, then the US says that good is subject to US law, and that good requires an export license to go from France to China. And there are a couple critical concepts there, right? It has to be controlled US origin content. So it's not any US origin content. It has to be US origin content that would require a license to go to China if shipped directly from the US to China. That sort of helps conceptualize it. If let's say a semiconductor machine, a die bonder is being built in France, and it incorporates certain key technology that's controlled for national security reasons, then if that US key technology exceeds the 25% threshold by value, then that die bonder in France is subject to US export control restrictions.
Okay.
It's a complicated area because it's a shifting number, meaning, like for instance, for Russia right now, there is zero de minimis threshold for goods going to Russia. So if something built in France contains 0.5% US origin content that exceeds the de minimis threshold for Russia, that requires a license.
So how does it work in the technology field? Like you talk about products, right? If it's intangible assets, a technology, know-how, how does it work?
So that's a very difficult concept, right? So software is a bit easier. You can value software. You can assign a value to the software. So if it's controlled software and that exceeds the threshold, that's easy. But and I've had this a lot, right? Where a foreign company is developing software and they have engineers sitting. There's some engineers sitting in the US. They have some engineers sitting outside of the US. They have to sort of assign a value to the code or information or software developed by the US engineer, determine whether that, you know, whatever he or she is producing is subject to controls, and then go with the analysis from there. So it's difficult for the company to figure out. It's also very difficult for BIS to figure out. And so most companies tend to play it fairly conservative, but in reality, it's very hard for the US to actually control and restrict this. Most of the time where the US is applying this rule, it's in a hard good space, right? It's machines, it's electronics, it's, it's very difficult for the US to actually pursue any sort of violation in the intangible space.
Yeah. When you say value, is it the value of the finished product?
Yeah.
Okay. I see. Yep.
All right. So direct exports, again, obviously this includes shipping a physical item overseas, but it also includes sending information by email, by electronic submission. It includes oral communications. It can include providing services, right? The installation of equipment, servicing, seminars, lectures, bidding. Any activity that serves to share with a foreign person controlled information or technology constitutes a direct export, which may be subject to a license requirement.
So a quick question: what is employment at the end of the list? What does employment?
So that's more the deemed export context, right? So yeah, if you have a non-US person employed at a US company, that could constitute an area for export.
Okay, so sometimes the Chinese company, parent company, would send people over to the United States, you know, to stay there for 1 month, 2 months, to work together. Not really, the US company does not pay them the salary, but in that circumstances, would that be considered as deemed export?
Yeah, so that you would have to, usually what happens is you have to, before that person gets to the US, the US entity would have to look at what it's developing. Does it develop controlled hardware? Does it develop controlled information in the context of developing the hardware? Will that foreign person have access to the information that might constitute, you know, controlled information? If so, you have two options. You can go get a license to share that information with this person, or you can just make sure that you have protocols in place to limit access by non-US persons to that particularly sensitive information during the context of their visit.
Okay, thank you.
So re-exports, again, it's just the concept that the US, more than any other jurisdiction in the world, has always said that US jurisdiction follows the product so long as it remains subject to the EAR. And so again, using the de minimis provision or the foreign direct product rule, so long as a product, no matter where it is in the world, remains subject to the EAR, then the US will say they have jurisdiction to enforce their laws and regulations. And deemed export, again, we've talked about this a lot. This is the idea of the sharing of controlled information in the United States to a non-US person. So in that context, who is considered a non-US person or a foreign national? Foreign nationals include anyone that isn't a US citizen, a permanent resident with a green card, or protected individuals, which are, you know, it's a limited scenario, but political refugees or political asylum holders. So if you are bringing someone over to your company, or if you're hiring someone in the US who is not a citizen or a green card holder or a political refugee, then you need to be concerned with what information they have access to in the course of their employment.
I see. You know, Matthew, it's very important because a lot of the employers here actually hire Chinese citizens who's on H-1B work visa. There was a lot of them. I mean, before, I mean, usually that's the route to go in to get green card and a citizen.
Yeah.
But a lot of them actually only have the work visa, working in the company as W-2 employees. So these people have daily access to that information.
Yeah.
That's considered as deemed export continuously, consistently. I see.
And in fact, in the context of hiring and the visa sponsorship rules, there's a form called the I-129 form. And that form actually asks the host, the sponsor, to state whether or not this employee will have access to controlled information or technology, right? So in the context of this hiring, companies should proactively be looking at what they produce, looking at what they have within their facilities. And if they determine that there is controlled information, a decision has to be made as to whether or not they're gonna, ring fence that specific information and not allow access, or go get a license to permit access.
Okay, I think I see a question on the chat box that's relevant. Somebody is asking whether the TN visa is considered as a foreign person. I think I can answer the question, yes, because TN visa is a work visa issued to Canadian, which I am a Canadian. I used to have TN visa for a long time. So it's sort of equivalent of H-1B visa, but it's issued to the Canadians. So that should be not US citizen, not green card, should be considered as foreign person here.
Yeah. I mean, one thing to keep in mind here is, even if you produce controlled information, you still have to make a determination as to whether or not that information requires a license based on the citizenship of the person, right? So to use the Canadian example, there is very little technology within the CCL or the EAR that requires a license to go to Canada. And so, Canada is not a great example, but something that comes up a lot is, again, certain software that includes encryption functionality that exceeds, very high thresholds is classified under 5D002. That's the classification we use. 5D002 technology and 5E002 information is controlled for national security. That can't go to most countries, right? So if you're hiring a software engineer that's going to have access to source code for a software that has very high encryption functionality, that's usually problematic. So it's a complicated analysis, but the first step is, what are we producing? Is it subject to controls? If not, then you can sort of hire who you want. If it is controlled, who are we hiring? What's their citizenship? Do we need a license to export this information to that country? No, then you can proceed with the hire, right? All right. The other thing to keep in mind on the deemed export front, because it can be alarming, right? This idea that the sharing of information is problematic. It has to be information that's controlled under the EAR, right? And anything that's public information, meaning that has been published in the context of scientific research, patents, any public information is not subject to the EAR, can be shared freely, right? So it has to really be, there has to really be an exercise of, what information sits within our company. Is it public? No, yes, then it's free. Is it proprietary? Then is it controlled? If it's controlled, can we share it with this person? So just a quick note on the technology, right? So, because it's probably the most complex area of this law. It's not any information related to controlled hardware. It's that specific bit of information that is required for that technology, for that hardware to exceed certain performance thresholds. So it's the analysis of determining what information can or cannot be shared is quite technical. But if you're conducting this kind of analysis, and if you do this, I would encourage you to work with somebody who understands these laws and regulations to sort of pinpoint what technology is actually sensitive. But it's essentially anything you're producing, any information you're producing using that is required for the development, production, or use of controlled hardware. And each of those underlying terms on this slide has a specific definition, right? So if you're producing information that is related to the development stage, this is, you know, anything at the design research, design analysis, design concept stage. If you're talking about production technology, it's information that is relevant to product engineering, manufacturing, integration, assembly, inspection, testing. When we talk about use technology, it's not just allowing a foreign national to use equipment, right? That's not a deemed export of information. It's, are you giving that foreign person information that is necessary for the operation, installation, maintenance, repair, overhaul, and refurbishing of a controlled machine? And all 6 elements have to be present, right? So it's actually fairly rare to have met all 6 elements and to have violated the use technology sharing prohibition. Again, I recognize this is a technical area, and we're condensing this into a short period of time. The bottom line is, be wary when you're hiring foreign nationals, and if you intend to hire foreign nationals, go through the process of analyzing what information you're using and producing to see if some piece of that information could be subject to an export restriction. Like I said, there are some information and software that is not subject to the AAR. That's anything that's published, anything that arises during or from fundamental research, things that are released in a catalog, a course catalog, things in patents, non-proprietary system descriptions, and certain telemetry data. I'll quickly, I know we're already running short on time. So assuming you do this analysis of whether or not I'm producing a hardware or software or technology that's subject to the AAR, the next exercise will be determining what is the export classification of that item. And to do that, you're going to go to this Commerce Control List, and you're going to look through the Commerce Control List to identify the ECCN that applies to your product, technology, or software. And the ECCN consists of a alphanumeric code, and I'll talk about that code in a second. First, I'll show you what the code looks like. Okay, so this is an example of equipment that's relevant to the biospace. This is equipment capable of use and handling of biological materials. So if you're producing or use 2B352 equipment, that equipment would fall within this specific ECCN, and the controls that apply to that equipment are based on this classification. And again, this is a highly technical analysis, which I'm having to break down offline, but the way in which you would figure out the code is to go to the CCL. The first digit is the category of the product. There are 10 categories, right? So category 0 relates to nuclear, 1 relates to materials, chemicals, microorganisms, 2 relates to materials processing, 3 electronics, etc. So you would say, I'm concerned whether or not my materials processing equipment is subject to the ECCN. You go to category 2. The second digit is the product group. So the product group is A for end items, B for test, inspection, and production equipment, C for materials, D for software, E for technology. And again, technology in this context is information. We're talking about a piece of testing equipment, so we know it's 2B. And then from there, it's simply a matter of going through that category and saying, what is the code that applies? And the way this works is that third digit will be determined based on the reason for control that applies. In this case, it's going to be national security. The fourth digit is whether or not the control is based on unilateral controls, meaning US only, or multilateral controls. There are some nuclear and arms related controls that apply around the world. And the fifth digit is just the sequential numbering. So you don't need to know this for all your products, but if you ever see someone ask for an ECCN, or if you see an ECCN applied to a machine, you know, this should give you a bit of a background as to where that number came from and what it means.
What are the typical reasons for control other than the national security reason?
Yeah, so national security, AT means anti-terrorism. CB means chemical or biological, which is actually one of those applies to this equipment here.
See.
There are crowd control, there are missile technology controls, there are a variety of controls. I'll have an example of a full list in a few slides. But so going with the same example, so assume in the context of your US operation, you do actually have equipment that's capable of use in handling biological materials. That equipment is classified under 2B352, meaning you cannot export that equipment from the US to a country for which, CB apply, whoops. I can't really highlight with my screen, but if you see here under the license requirements, reasons for control, you can't export 2B352 equipment to a country for which one of these reasons for a control applies. And you would tell yourself, well, how is that relevant? Well, so let's say you have a piece of 2B352 equipment in the US, you want to export it to your sister company or affiliate company in China. You see that this is controlled for CB column 2 and AT column 1. You then go to what's called the Commerce Country Chart, which is on the screen now. You look down at the bottom of the screen, you have China, right? So you would then scroll across and see the second column actually is CB2. If there's an X in that box, that means that items controlled for CB2 cannot be exported to China without a license. So again, the analysis is I have this piece of equipment, it needs to go to China. It's classified under 2B352. It's controlled for CB column 2. If I look at this chart, it cannot go to China without a license. The next step then would be to actually go to BIS and say, we would like to apply for a license to share this piece of equipment with our counterparty in China. You'd have to provide them a full explanation as to why you deserve a license, why the counterparty is not affiliated with the government or any military end use or military intelligence end use. You'd have to make the case for why this is not in violation of US foreign policy or national security laws. But bottom line is the analysis should be sort of a review of what you're producing, what you use. If you need to share that, then you have to go through the process of classification, identifying reasons for control, and then comparing those on the Commerce Country Chart against the list of countries with whom you're trying to share the product. And I'll back up really quick. Most companies just self-classify, meaning they independently or with their own engineers or with their own specialists go through all of their products, go through all their equipment and figure out how items are classified. You can actually, though, go to the government, go to BIS and ask them to give you a binding ruling on the classification of a certain item, software, technology. That process is called the CCATS process. So assuming your product is under BIS jurisdiction, the agency will give you, and they usually are pretty good about returning this within a month and a half to 2 months, their binding ruling on how your product should be classified. But the challenge is, like with most agencies, they tend to be fairly conservative. And so whereas you looking at it by yourself or with your specialist might come to one conclusion, on balance, BIS likely will take the more conservative position, and then you're stuck with their classification. Like I said, if you go through the analysis and you determine my product is subject to controls, it can't go to China without a license, you can go apply for a license. Even in the context of Huawei, right? So we all know that the US placed very strict controls on things going to Huawei. Well, in reality, upwards of 80% of items for which US exporters requested a license was granted. So just because the license requirement applies doesn't mean that you should not pursue the license option. There's a good chance of you actually getting the license if you make a good case for your export. This is just the system that we use to file license applications. The same applies for deemed exports, right? So if you have controlled information, but you want to hire a Chinese engineer or an engineer from any other country If it's worth it for you to let that person have access to the information, you can go to BIS and ask for a license to share the information. And in many cases, these are granted. I'd say in most cases, these are granted. It requires you to provide, fairly detailed list of information related to not only the employee, but what you intend to share with them. And it also, one second. It also requires that you explain in your license application, what safeguards you have put in place as a company to avoid the release of sensitive information to non-US persons. In most cases, it's called a technology control plan. And that's sort of part of the analysis, right? It's not just how badly do I need this foreign employee? It's, am I willing to go the additional step of creating compliance and internal controls measures to avoid the release of information and to make sufficient case with the government.
Matthew, how quickly that the government will get back to on that? The license.
Yeah, I mean, it's not instant, but I would say in most cases, within 3 months, you can get a deemed export license.
Maybe it's recommended that when this person is processing, sort of applying the visa to enter into the United States, at the same time, he can submit that application, the license application.
Yeah. I mean, particularly in the, again, if it's an employee for whom the company is completing the I-129 form, then the government is essentially already on notice that this person will get or may get, access to controlled information. I think at that stage, if you're checking that box, then that's the point at which you would go ahead and file for a deemed export license up. Again, technology safeguards are simply, if you decide to go that route and you file a deemed export license application, make sure it includes a description, again, of how you as a company are going the extra mile to protect access to controlled information. And it should include a physical security plan, as well as obviously an information security plan. It should include, procedures for screening personnel. It should include an examination of how you are training your employees to implement the technology safeguards. And it should include sort of periodic, ongoing self-evaluation protocol. And I know we're short on time, so switching to more China-specific issues, despite how it may seem in the news, there's still a policy of approving most licenses for exports to China, assuming you can demonstrate that the export is for civil end use, right? The U.S. government is very wary of sharing controlled information or technology or hardware with anyone associated with the PRC government, or particularly the military branch of the PRC government. But so long as you can show civil end use, most license applications are granted. Again, like I said, there's a focus on sort of the civil military fusion and whether or not who you're sending it to has access or is linked to the government and the military complex. But again, assuming you can make a case for civil end use, most applications will be granted.
Sorry, Matthew. So the U.S. company here, if they're going to export some technology to sort of like a middle person and they don't know who the end users is, so is it their obligation to find out who is the recipient, who is the end users of that technology?
There's no obligation to find out who the end user is beyond your customer. But what usually happens is it's a matter of due diligence, right? So if it's a particularly sensitive item and you know that your customer is a distributor, then the government would probably expect you to go the additional mile of saying to your distributor, who do you intend to sell this item to, right? It's possible that the distributor doesn't know, right? They're stockpiling inventory. If on the other hand, you're selling it to a specific end user who's not a distributor, the government wouldn't have an expectation of you, going further than your immediate customer. So it's a loose line. The due diligence line is loose. It's a matter of how sensitive is the product or information, what is the nature of your customer? Are they a reseller or do they intend to use it themselves? Based on the nature of the transaction or the nature of the market, are most of these goods resold, right? Depending on your understanding of risk, you would want to conduct additional due diligence steps. So beyond the general license approval policy for Chinese exports, there have been, particularly in the last 4 years, a lot of entities and individuals in China that have been added to denied and restricted party lists. The primary one is the entity list, right? So there are, again, based on foreign policy or national security reasons, the US has added specific end users, meaning individuals and entities, to the entity list. Exports to anyone on the entity list, regardless of how benign the product is, are forbidden without a license. So even if you wanted to send pens, hats, sunglasses, whatever it is, if it's going to someone that's on the entity list, you have to get a license for that export. The way, it's a fairly easy risk mitigation process here. You should be screening all of your counterparties against the US's consolidated screening list. That will tell you whether or not the parties that you are dealing with are subject to a denied or restricted party restriction. Beyond the entity list, there's something called the unverified list. And this, there was a period where China was essentially not allowing the US to come in and conduct end-use verifications. So the BIS would say, we have someone who wants to export something to this end user in China. We have some doubts about that person. We'd like to come to China or send someone to China to conduct an end use verification. If the Chinese government says, no, you can't, then that person automatically will go on this unverified list. So it's not the entity list. It's not the government saying that person is a threat. It's the US government saying, we don't have enough information on this person, and so we're going to put them on this sort of temporary list. And that can be just as devastating commercially as the entity list. WuXi Biologics was put on that unverified list back in 2022 because the US had some doubts about them as an end user and weren't able to conduct that sort of bona fides review. And for WuXi, that was devastating. Their stock price plummeted. A lot of financial institutions and suppliers didn't want to deal with them anymore, right? So it can be as devastating commercially as the entity list. Just quickly, there's a thing called the validated end user program for Chinese end users. You can essentially go through the process of pre-validating your end user and getting approval from BIS to assign that entity the VEU title. And that means that once you're a VEU, you can get products from the US that would normally require a license without your exporters having to go to the trouble of getting one. So it's essentially sort of a stamp of approval from the US government that says, that party is authorized to get controlled, information or software or products without a license. So again, this would only be worth it if the Chinese entity took in a lot of exports from a lot of different companies. But if that's the case, then this is a valuable opportunity. Real quick, relative to the life sciences and biotech industry, this is an area that the US is increasingly focused on. Biotechnology specifically has emerged as one of the emerging technology areas that the US feels it should be more focused on, particularly in the biologics area and the DNA area, right? So that there may not be controls now on the type of information or software you're dealing in, but it's an area of focus and controls will start to emerge over time, particularly if the relationship between the US and China deteriorates. So as an example, in the past couple of years, BIS added a couple new ECCNs that are related to biotech. They added 2B352B2B, which covers single-use biological cultivation chambers with rigid walls. and 2D352, which is software designed for nucleic acid assemblers and synthesizers. So again, these are very specific ECCNs, and these emerge from BIS identified a concern about the sharing of these items between the U.S. and foreign countries. And so as the US gains a better understanding of what is being shared outside of the US and what is of particular concern, there may be new categories and new reasons for control. And these are very quickly, these are some other areas that if you're dealing in these areas, you should be reviewing the classification of your product, software, technology, and figuring out, again, are you sharing this information with people outside of the US, or are you sharing it with non-US persons within the US? So if you deal in biological agents and genetic elements, if you deal in vaccines, if you deal in biological processing equipment, if you deal in technology related to any of the above, meaning, again, information necessary for the development, production, and use of specific equipment, then you should at a minimum be conducting an internal survey to see whether or not you have concerns around exports or deemed exports. Let me just check the chat here.
Yep.
Okay. Yeah, so there's a question about screening, which is, that's a good question. Briefly, I'll screen. I mean, again, we're going to share these slides with you, but these are some very basic, high-level general compliance best practices, and screening will be included in these. So you should have, again, if you conduct that inventory of what you're doing and what you're producing and what information you're relying on, and you determine that there is a risk for export controls violation, you should put in place a written, formalized policy manual that lays out essentially who's responsible, what the roles and responsibilities are, what are lines of reporting, what information is captured by the document, and how you're going to go about controlling access to that information, what your license determination policy is, what your policy is if you determine there's a violation, et cetera. And a successful compliance program needs management support, meaning you have to get buy-in from management, coordination of efforts, communication between departments, cooperation between departments. All these procedures should be written down. There needs to be training provided to employees that have a role and responsibility or function within the export controls area. And then, all of these programs should include a periodic auditing protocol as well. In establishing internal controls around export controls, you really need to be paying attention to red flag indicators, right? I touched on this briefly. Not every export transaction is the same from a risk perspective, right? Based on what the product is, based on who it's going to, based on what the end use might be, based on the destination, that might create a higher risk or a lower risk. And with a higher risk, your due diligence should also increase. You should be obtaining detailed information on customers who present specific risks. You should be screening all of your foreign counterparties against the consolidated screening list. I think that's in here. You should use information technology to augment your ability to screen, right? So there is the US government provides a consolidated screening list. There's a link that if it's not in this deck, I'll make sure it gets sent out to everybody. But you can manually go in there and screen all of your counterparties against all of the US denied and restricted party lists, not just BIS, but also sanctioned. But there are also lots of software providers who will give you access to software that allows you to dynamically and on an ongoing basis screen your counterparties against all of these specific lists. We talked about written policies and procedures. You should have one person within the organization that is assigned primary responsibility over export controls compliance. That person should have enough authority to actually carry out that role, preferably someone that has access to upper management. Again, training. Here we go. So the second bullet, again, screen all parties to a proposed transaction against all government published control lists. So again, not just those lists that are covered by the EAR, but those lists that are covered by State Department export control regs, Treasury Department OFAC sanctions, and any other lists that might be applicable. Most companies go beyond the US list. They're also screening against UN sanctions lists, EU sanctions lists, and potentially UK sanctions lists, right? So the consolidated screening list that's provided by the US is obviously US centric. Most companies that use outside software providers, those providers allow you to screen against many countries' lists, not just the US.
So Matthew, these lists are not public records, are they?
They are public records.
Yeah, supposed to be. Okay. And in terms of training, what is the best way you recommend for companies to get training? I mean, a lot of companies don't have any idea about this.
Yeah, I mean, the trick is it needs to be sort of tailored to the risk, right? So if you do an inventory of everything you produce and use and and information that you generate, and you say, we have one machine in our whole factory that's subject to export controls. You don't need a large program. You don't need this extensive training program, right? You should basically have a protocol in place that says, if that specific product is subject to being exported, one person is designated as responsible for ensuring that it doesn't go to someone that it shouldn't go to, and that one person should receive, at a minimum, enough training to know that how to screen counterparties and how to determine whether or not a license is required based on an ECCN classification, right? And that training can be, BIS itself offers a lot of very useful background information and training documents. BIS has online webinars that are very helpful. They offer very comprehensive two-day export controls compliance training for free. They offer this around the country on a biannual basis. And there are also, in addition to myself, there are lots of consultants and lawyers and specialists who provide, in-person or online training opportunities.
Okay.
But really, I always say it should be tailored to the risk, right? If you have a very low risk, you shouldn't be putting in place a 50-page, manual. You shouldn't have 40 people going to export controls compliance training. It really should be tailored to your specific risk. The one thing I wanted to add at the end here, and then I'll pass it over to Connie for questions, is again, just to make sure, I know in many of your cases you have connections to foreign entities. If you're bringing in visitors, even if they're not employees or hires, even if you have visitors that are not US persons, you should have a policy in place for how to screen those visitors, figure out what their citizenship is, determine whether or not, based on that citizenship, they should be restricted from accessing machinery, equipment, software, or information. There should be, and most companies that have this, right? There should be, at the initial entry point to the building, there should be a sign-in sheet and a badging system. If for some reason you do figure out that you're bringing in someone who shouldn't see something, that person needs a specific badge that identifies them as, someone who shouldn't have access. And that person you need to make sure that person is kept away from sensitive information. So yeah, so again, I know I went over a lot of information in a short period of time. If I can leave you with the two key things are, do a personal inventory of, again, what you're producing, what information you're relying on to produce it, what equipment you're relying on to produce it, and what software you're relying on to produce it. If you think there is something in that mix that might be controlled for export, then look at who you're exporting to and look at who comes to the US and who might have access to that information. Put those two things together, and if you still think there's a risk, then explore the idea of developing a more complex or comprehensive, written protocol, and or applying for a license. And with that, I'll pass it over to you, Connie, for questions.
Oh, thank you very much, Matthew. Do you want to go to the last slide to show your contact information?
Yeah.
So this is Matthew's contact information. It's super informative, even for me today. I would like to, if you have about 10 minutes, let's handle some questions. Let's go through the questions from the chat box first, and then if we have any time left, we'll open up the floor. So Matthew, the first question is, in a biotech company, small, large, molecular, or gene therapy, what kind of technology or news considered as deemed export? I think deemed export, yeah, it's, go ahead.
Yeah, so it's a complex question because most you sort of have to work back from what the end product is. If the end product is controlled, then information that is necessary for the development, production, or use of that end product is probably also controlled. So it's hard for me to say based on a specific industry vertical whether or not that industry vertical has controlled information. Look at what ultimately will be produced using the information you're working on. If that's controlled, then your information may be controlled as well. But even then, remember, you still have to identify within that bucket of information the specific information that makes that information exceed the control parameters. And only that specific piece of information is subject to control. And even then, the next step then is, okay, sure, it's controlled information, but is it controlled for AT, anti-terrorism, in which case it can go to almost anyone? Or is it controlled for national security, in which case the amount of people it can go to without a license is pretty restricted?
Okay.
So it's a tough question to answer. I'd really have to know exactly who you are, what you're building, or what you're producing, what information you're generating, to have a more concrete answer than that.
Okay, thank you. I think we have, I'm just going through the questions. The next one is there a good approach to screen the vendors which might be on the restriction lists?
Yeah, so let me hop off of my deck and I'll show you live what the hold on. Let me open a new window here.
Sure.
Is my screen still being shared?
Nope, at this point.
Let me share. All right, how about now?
Yep.
Okay, so you would just go to the, it's as easy as Google Consolidated Screening List or Bing or whatever your search engine is. This first link here, the International Trade Administration is the host for this consolidated screening list. So click on that. This has an explanation of what it is, right? But what the link you're looking for is this first link here, Consolidated Screening List Search Engine. And this is it, right? So you can go to, for any export transaction you're considering, you can go to this link and we can figure out a way to share this link with you. And it's as easy as, so let's say WuXi Biologics. So no result now because they're not on the entity list anymore. Let's say, so let's make it easy, Huawei, right? Right, so 137 results. There are 137 specific entities associated with Huawei for which a license requirement of some form is required. Is required. This is the first entity, obviously. So if you click on each entity, it'll tell you what list they're on. In this case, the entity list, the start date, the Federal Register notices that are relevant, and then any specific addresses and affiliate names that are associated with this entity. It'll even give you here the presumption of denial, right? So whereas as I said earlier, there's a license policy of approval for licenses to China for civil end use. With regard to entity list entities, the license policy is a presumption of denial. So Connie, we can share this. Actually, let me, maybe I can even, I'll put it in the chat. That's probably the best way to do it.
No, that's the best way. It's very helpful.
So that's the, that's the easiest way. And then of course, if you have, honestly, if you have even a dozen per week, you can still do it manually. If you're the type of company that has, hundreds of or thousands of export transactions per year, you probably should have a software provider that can help you screen on a much more diligent basis, right?
Okay, super, thank you. Next one is, if receiving the EAR 99, does that indicate a green light for exporting?
So going back to that idea of the consolidated screening list, hold on. So sure. All right, I won't go back to my slides, but basically, the Commerce Control List has a full list of specific ECCNs. If the product isn't covered by a specific ECCN, it falls into an EAR 99 bucket. That's sort of the catch-all bucket for everything that's subject to the Commerce Department jurisdiction, but not specifically called out. It is the lowest level of control, but even EAR 99 items cannot go to entities that are on the entity list, right? So they can go to China, they can even go to, in some cases, well, before the full set of controls, they could go to Russia, right? Now they can't. But if you have an EAR 99 item, it doesn't mean you can send it to anyone you want to. They still can't go to embargoed countries like Iran, Russia, Syria, Sudan, Cuba. And they still can't go to entities or individuals that are denied or restricted. So you should still be conducting that screening exercise that we just walked through.
Okay. All right. Selling scientific software, is there an exemption if it is generally available to the public?
Yeah, so that goes back to, is it actually subject to the EAR? If you can demonstrate or support that it's generally available to the public, then even if it has, so it's a complicated area. It's called there's a mass market software exemption. So even if it does incorporate certain encryption functionality that would usually make it subject to export control restrictions, if it's say like a Microsoft product, right, that's generally available to anyone, then it'll get the mass market designation and you avoid the license requirement. And even beyond that, if it's just generally based on open source software or open source coding, in most cases that wouldn't be subject to the EAR. So you have to really look at the specific source code of the software and say, is the source code actually open? It may not be subject to the EAR. Even if it's proprietary, does it incorporate encryption functionality? If it does it qualify as a mass market item for which a license would not be required?
Okay. We got two last questions to cover. This is an interesting one. If I'm not sure about the product classification, is that better to consult with a lawyer first? I would say yes. If we write the email to BIS or CBP, they give us conservative answer. Do we have to follow?
Yeah, I mean, so it's a self-serving answer, but yeah, you should. I always encourage people to, and not necessarily lawyers, right? I know some consultants in the export control space who are very good at technical classification, probably even better than most lawyers. But consult with somebody who really understands the Commerce Control List, because if you can build a case for a reasonable classification, it's usually less conservative than going to BIS. And same thing on CBP only restricts import items, and they do also provide ruling guidance. But same thing, CBP tends to be more conservative than an importer might be if conducting their own reasonable due diligence.
Okay. Awesome, Mr. Buck, very nice presentation. Yes, and you talked about export control. Is there control for import materials from China?
Yeah. Probably, frankly, broader controls, right? Not controls in terms of a prohibition on things coming in, but increased tariffs that are designed to restrict the importation of certain items, right? So based on the origin of a product, if it's Chinese origin, and based on the harmonized tariff schedule classification of that item, that product might be subject to tariffs that are 25%, whereas it would be 0 coming in from another country. And not to talk about the election, because that's a whole new issue, but I suspect that over the course of the next year there will be increased tariffs on Chinese components and goods. And so again, it's not a prohibition like on the export control side, but it's designed as a sort of non-trade barrier to entry.
All right, super. Okay, I think we are right on time. I really appreciate it, Matthew. Thank you so much for the
Yeah.
presentation.